Welcome everybody to the Private Law Pick and Mix Case Updater seminar. This is the third seminar in the series. The two first were given by Rachel and Charlotte, who did a seminar on witness statements in private law proceedings. The second was on the assessment of ethnic minority families, which was done by Sharman and Hazel. And on the 23rd of November, there is going to be a further seminar to do with proportionality of care orders and their impact in the context of REHW. So today, our seminar is a case law update. We had hoped that the juxtaposition of the words case law update with something fun would lure people into attending on a dark, rainy November evening. And we can see by the alarming numbers in the right-hand corner of the screen that it seems to have worked. So thanks very much for tuning in. We know there's quite a storm out there, so hopefully none of you have been too badly affected. And the way that we're going to do this talk is just to have a quick run through some short cases, some short cases, and then maybe a deeper dive into a couple of more chunky cases towards the end. Just a very quick update. Hopefully you'll all be aware of the fact that there was some new template orders that were circulated in June of 2023 by Mr. Justice Peel, and they were actually updated last week. The reason for the first update back in June was because there were some errors on the warning notices for occupation and non-molestation orders. So that's particularly important that you're aware that you're using the most up-to-date template orders for those two types of cases. And that actually comes in very neatly for you, Sam, and the first case we're going to be discussing this evening.
Well, not sure how neatly it flies in, but yes, I was...
About non-molestation orders.
Well, yes. There hasn't been any dramatic changes, well, certainly not in this case, in the law relating to non-molestation, but what there was about 8 to 9 months ago, so still within 2023, was a very good summary of the law in DS and AC, in a case that was heard by a High Court judge in Birmingham, which you may or may not have picked up on. And basically, what Mr. Justice Eléonore said was there hasn't been a reported case, that's dealt with the principles to be applied in non-molestation cases in some while, and therefore she wanted to set out some of the main principles, which I imagine and hope we're all very familiar with. And the driving thrusting point that comes out from underneath it is one that has been drilled home, I know, to a lot of us over recent years, and certainly over the last decade, which is you should only be making ex parte non-molestation applications if they can be justified and there's an urgent need for an ex parte application. And yet, despite that guidance, far too many applications are still made on an ex parte basis, presuming that the default order will be that an order will be granted simply because you are there, and we should not be doing that. The point that Eleanor said to me beforehand is it's not entirely correct that there have been no reported cases.
Sam feels quite strongly about this.
So it's not quite right. There have been no reported cases touching on the principles around non-molestation orders. I'm aware of a few that perhaps weren't drawn to the attention of the judge. One of them I featured in, not as a claimant or respondent, but as counsel Q&Q a few years ago. But nevertheless, this is an excellent summary. At paragraph 18, the court draws together some of the key threads, and at paragraph 23, then extracts the principles. And none of these principles, I say, will be new to us, but it's worth refreshing our minds. The principles that can be really applied when considering a non-molestation application. First of all, on a without notice application, the court must consider whether there is a risk of significant harm attributable to the respondent if the order is not granted immediately. Secondly, whether the applicant would be deterred or prevented from making the application if the order was not granted immediately. Thirdly, without notice order should only be made in exceptional circumstances and with proper consideration for the rights of the absent party. That third limb is probably the one that most weight needs to be placed upon, certainly for the purpose of this discussion. Fourthly, the court should use its powers under the FLA with caution, particularly at a one-sided hearing or necessarily on a paper consideration without the other party having notice. Molestation, fifthly, does not imply necessarily either violence or threats of violence, but can cover any degree of harassment that calls for the intervention of the court. And then sixthly, the primary focus of the court should be upon the harassment or alarm and distress caused to those on the receiving end. Seventhly, there does not have to be a positive intent to molest. And then what the judge underlined is that point I already made right at the outset. When you're applying those factors, it's very important you don't presume, and the court doesn't presume, that the default order should be for the granting of a non-molestation order on an ex parte application. In fact, the default should be it shouldn't be granted. And what is clearly underlined, and what I know we all know already, is that in your supporting statement, if you're representing a party that's making an ex parte application, you should specifically explain in a section within that statement why this application warrants an ex parte order. What is it that makes it exceptional? What is the significance of the risk? And certainly my practice, when I deal with non-molestation applications that have been heard ex parte, sometimes that is the element that in particular is missing. So whilst it's not new law, it is worth perhaps having a quick read of what is a very short 29-page judgment in DS and AC. And we're 29 paragraph, I should say. There's a slip. That's unfortunate. And we're going to circulate after the seminar, I know, a document that sets out these cases, so you'll be able to connect to it very quickly and very easily. The only other thing I would add, it's not in the judgment, but is something that I'm aware is getting missed more and more, is we are now fully into, and have been for some decades, the internet age. And it seems that issues of harassment and molestation are widening in scope on an annual basis and drawing in greater and greater issues of third parties. You're not just seeing regularly now, certainly I'm not just seeing issues of molestation between one or two parties or within the family. More and more it's drawing in third parties. And of course, if you have a case that involves not just two people, but wider issues of social media, wider family members, friends, colleagues, the public generally, you might well be dealing with Section 12 of the Human Rights Act as well, if you're looking to get an order that restricts somebody's freedom of expression, and you might well also be falling squarely within the extra restrictions in that provision if you're appearing on an ex parte basis. So in the round, the first point to be delivered in this Pick and Mix Kate update is continue to be alive. The caution that should be exercised if you're making an ex parte non-molestation order application, and make sure it's properly justified and made out, or you risk sadly falling on your face when you get before a judge, certainly if they've read this recent judgment. I don't know if you have anything to add to that.
Gosh, I mean, where do I start? Because it's just such a pitfall in the cases that we do, and particularly, as you say, that very first hearing in such an application, if that part of the witness statement hasn't been sufficiently justified and articulated, really quite a lot of close attention needs to be paid to that. Otherwise, it's just a non-starter. And I see that very frequently when I get bundles now, and I look back through the history of why it was that a non-molestation order wasn't granted at the first hearing. Typically, that is what it falls foul of. Sometimes it's because it's obvious that the content of the molestation hasn't been sufficiently detailed, but quite often the hiccup, I'd say in the majority of the cases where I see that, is to do with the fact that the urgency and the reason for the application being made up ex parte isn't sufficiently justified. I think there's another interesting point to raise from that, actually, which is the evidential difficulties around trying to get parties who are third parties, or rather trying to get the respondent, preventing them from getting their friends to harass somebody via social media. But at the moment, I think the best that we can say is the law doesn't really cover that point adequately, as you pointed out. So the next case that we're going to be discussing is the case of AY and another versus ZX, which is a decision of Mr. Justice MacDonald in what I think can broadly be categorised as a Turkey-based case. So it's to do with parental orders, and the short point is that this is quite a useful case which confirms that a parental order can be made even if a surrogate is artificially inseminated at home rather than in a licensed fertility clinic. And this case arose out of what is now, I think, probably an increasingly commonplace scenario which is that an individual named ZX, who was a friend of AY and BY, offered to be their surrogate. And ZX was artificially inseminated at home using AY's sperm. She duly became pregnant with twins who were exclusively cared for by AY and BY from the time of their birth. So this wasn't a case where there was any level of animosity between the surrogate and the intended parents, but rather it was to do with the fact that the magistrates before whom this case was originally heard didn't think it was possible for a parental order to be made. But the point is that the case was allocated to the magistrates. Nobody really knows why. The mystery behind certain allocation decisions remains unfathomable. It was eventually transferred to Mr. Justice MacDonald because the legal advisor thought that it wasn't possible to make a parental order in these circumstances. And effectively, that case very neatly sets out in a few short paragraphs that the relevant statutory provision is Section 54 of the Human Fertilisation and Embryology Act 2008, not Sections 33 to 53. And there's nothing within Section 54 that says you can't make a parental order where somebody is inseminated somewhere other than in a licensed fertility clinic. So helpful little case there for anybody who turns up in a bit of a flap thinking that perhaps they haven't done things quite the right way, or in case you inexplicably have such a case allocated to magistrates and they make the wrong decision. Sam?
Makes sense as well, that decision. I'm then going to deal, and we are rapidly moving through our pick and mix box, in a little bit of detail, with a case that I know we're probably all, again, quite familiar with. It was everywhere at the beginning of the year and moving through the summer, which is re-see parental alienation, touching upon those points fleshed out by the President in relation to the instruction of experts in parental alienation cases. Before I do that, because this is pick and mix in a slightly chaotic fashion, I would make this point, which may be helpful. And again, it is something we all know, but there have been a slew of recent appeals and judgments in relation to a failure by courts to implement participation directions and/or proper special measures, but really participation directions in cases, and in particular fact-finding hearings, to guard and protect vulnerable witnesses so that they can give their best evidence. I know this is cropping up in all sorts of training forums that we all attend regularly. And there have been a number of full fact-finding decisions that have been set aside. And effectively, parties, having gone through extensive multi-day fact-finding exercises, are finding themselves repeating them on occasion. And certainly this has happened in at least one of my cases that's come to me post-appeal, which is terrible for all the parties involved. And so whenever you're going into a fact-finding exercise, I'll provide a list of some of the cases which are quite interesting and flesh it out in full detail when we circulate our note. Whenever you're going into any hearing at the moment where you know there may be a concern about a party giving best evidence, in particular a fact-finding hearing, make sure that you have considered participation directions and that they have been fully canvassed. Make sure that there is a hearing that is going to deal with them, and make sure that there is an order that deals with the decisions made as a result. Do not end up in a situation that a few people have ended up in, where you have an appeal judgment after a fact-finding hearing that notes that at the PTR or directions hearing before the fact-finding hearing in issue, no one sought participation directions that are now noted to have been completely necessary. Dealing then, jumping from that short reminder to re-see, I won't deal with the factual background because it's not enormously important to the core issues. What this case deals with, so far as it is useful to our general practice, is how we should approach experts, both particularly psychological experts in alienation cases, psychological experts generally. And it also touches, of course, upon the rules in relation to experts generally. What was at the heart of the case was in a case where a psychologist had come in, some that call themselves psychologists, but it wasn't a psychologist, had come in and given expert evidence that had led, it appeared, to the parties findings, certainly heavily contributed to findings, been one of the three limbs that the judge at first instance had based her findings upon. Was it right that that person could have come in as an expert in relation to alienation or as a psychological expert if they weren't some sort of accredited psychologist if they might not necessarily have underlying qualifications or be attributed to a registering agency or authority. What was determined, as I say, I'm certain this will not be news to anyone. It made the national press at the time. What was determined is of course, simply the procedural rules, which is that there is no law or regulation binding the court only to seek accredited experts or experts with certain degrees or qualifications, whether someone has relevant expertise which will necessarily assist the court in any case. It is a question of fact for the court. However, what was underlined by the president is if you are looking to use an expert, that is not, in this case for a psychologist, HCPC regulated, or you're looking at someone that is not associated with an accredited body or an accrediting body, when you know there is an accrediting body for that area of expertise, you should identify that and explain to the court at the earliest possible opportunity that they're not, but their expertise is still suitable for reasons X, Y, and Z. That's important. You can't just ignore the issue, but that isn't a bar to that person being an expert if they do have suitable expertise. One of the things that I talk about a bit when I speak to clients and solicitors is the scramble that we so often find ourselves in when we have a case that suddenly needs an expert. We identify a broad area of expertise, whatever it is. This is moving away from VC now. And suddenly we're racing around going, well, who can we put forwards? How can we shortlist 3 or 4 experts for this case? And it always seems to be done on reasonably short notice. And everyone's always talking rapidly and using their networks to find people that might fit the box of that case. And I think just very general advice, I know a lot of people already do this, is make sure you are collecting lists of experts and different areas of expertise that you know are good and that you know you don't like for whatever reason, noting their expertise and their qualifications, so that if in the future you have a case that needs expert Y, you can turn to that list and swiftly identify who you might want to draw upon. And that is far better than 4 days before the hearing, trying to work out, or 4 days before the application is put together, trying to work out who you might want to put forward. I don't know if you disagree with that.
No, I totally agree with that. I was going to say that it's in that scenario, and this is also maybe departing a bit from the case of VC, but I think it's an important practice point that quite often what will happen is that you dredge up maybe one CV, and in the moment you think, yeah, that's good enough, and everybody agrees, and it creates further difficulties down the line. Or you find yourself in a situation where timescales is the determining factor as to who is instructed. But of course, not all CVs are created equal. And even some pretty good CVs on closer scrutiny, or if you're aware of that particular expert's actual corpus of court reporting, may not necessarily be the person you want to choose. And certainly I've added, well, a couple of names to that list of people I don't want to instruct just in the last week. One of whom was instructed in essence because there wasn't really anyone else, and the timescale fitted in with the court's timetable for these children. And what happened was that that report was so poor in quality that it actually prolonged the proceedings by a further 5 months, because in substitution for that expert, an expert psychiatrist and a consultant paediatrician were instructed by the court to carry out some further work. And that is because the original expert, who was a psychologist who had actually on the face of it an OK CV, had diagnosed the mother with Munchausen syndrome by proxy, Munchausen syndrome, and also fabricated illness, which, as far as I'm aware, isn't in fact a diagnosis, but there we have it. So yes,
well,
we're experts.
It brings us full circle, in fact.
I'll share the name with you later.
It brings us back to VC, because actually one of the words that's repeated most often in VC by the president is the word caution when it comes to experts, when it comes to identifying appropriate experts, making the application, working out whether they're going to be right for the case. A crazy summary there. These aren't the words of the expert, with the president. Some free advice stepping away from VC. It's my strong opinion that the fastest available expert report is very rarely the best available or possible expert report. And if you're left in a situation where every expert you want is unavailable for 3 months, but someone you've never heard of can turn it around in 2 weeks and seems to be sitting, twiddling their thumbs, raring and ready to go, you want to probe why that is, not simply accept it as the gift for the case to resolve the expert conundrum.
Yeah.
And the other great failure, this is what's not so much a failing, but caution that must be applied is, and this actually did feature in VC, where somebody else, particularly someone you respect, the guardian in a private child case, proposes an expert and that's all you have. Don't just rely upon their proposal because they are the guardian or because you respect the representatives a lot and know that they're very good lawyers. Still do your own research into who that person is.
Some of them are attending this talk, Sam.
Yes.
Yes, no, I completely agree with that. So sorry for the digression in relation to experts, but as you can tell, we feel quite strongly about that just because it causes so many problems. And I think we see, personally, I think I know it's a very chunky decision, but it's worth taking a little bit of time to consider it because it may get you out of the fix and also prove persuasive if you find that actually the only expert is the one who can report in 3 weeks' time and nobody's ever heard of them.
No, well, experts are, we both feel very strongly about it, but there's few things worse than having got a single joint expert report that is singularly very important to a case, having advised the client that that expert is singularly very important to the case, having had them pay for it in a private child case, and then turning up to trial and knowing that the core component of your strategy is making sure that that single joint expert's opinion is either substantially changed or disregarded because it is so unhelpful or awful.
Well, actually, the case that I was in earlier this week, the advocate took the view that we needed at all costs to avoid a scenario where this expert was giving evidence because actually the conclusions weren't helpful to anybody. They had made it incredibly difficult for the parents to adopt anything like a sensible approach when it came to making proposals. And eventually we were able to swerve away from having what would have been an absolute bloodbath of the final hearing because the guardian went out, saw the children, reflected, came back, and actually we were able then to sidestep the need for that expert to give evidence and the case settled. But there we have it. But anyway, so that's experts.
And back to your next pick and mix case, because
yes.
I'm dominating.
No, that's
at the
absolutely
time.
fine. Well, we both are because we both regularly have rants about crap experts, but there we have it. So moving away from experts and into the field of procedural irregularities, appeals, etc. So it's a case called Re-H, a child recusal, which I thought we discussed because it is something which happens from time to time that clients will say, well, I think judge is biased against me. I want to have a different judge. I'm not happy with what has taken place. Or the other side make that very submission. And it turns into really a bit of a distraction. And so I think that this is a case which bears, it's not very long, it's a decision of Lord Justice Baker. It bears a little bit of reading just because it will, I think, help all of us to explain to clients in very short form why it is that although they may very well want to have a change of tribunal, first of all, that tribunal wasn't in fact biased, or that really the chances of making the application won't fly, because so often that's the case. Of course, if the contrary applies, then you'll be able to confidently advise them. So it neatly summarises really in a private law scenario the status of the law. And these were private law children proceedings where the father had applied for a child arrangements order, specific issue order, and a PSO against the mother who'd left with the child to move into a refuge. And the court ordered a fact-finding hearing, which had taken place. There had been a number of case management decisions leading up to that fact-finding hearing, which gave the father, it's there to be said, quite a short time to comply with certain directions. But ultimately, the court did make findings of coercive controlling behaviour against the father, together with various other findings of abusive behaviour. The Section 7 report was ordered, which recommended a change to interim arrangement, which reduced the time that he had with his child further, and that was endorsed by the judge. He then, that's the judge, dealt with further application from the mother, amongst which were a decision for the child to have a flu vaccination, and the matter was eventually set down for a welfare hearing. And before that took place, the father invited the judge to recuse himself, and the judge refused, and the father appealed. He succeeded in the High Court, The mother appealed against that decision, and she successfully appealed the High Court decision in front of the Court of Appeal, such that effectively the original judge did not have to recuse himself. And there are a few points to be raised from this. First of all, beware cases where there is a multiplicity of applications, because what that really means is that parties are just very deeply unhappy with what's going on and their feelings aren't being adequately managed. And that might indicate to you that perhaps they will need some support, which is really beyond what we as lawyers can afford. But the second point is what this decision tells us, which is that in order to determine whether or not a judge should recuse themselves, it is necessary to consider the whole of the proceedings to determine whether the judge's approach to the aggrieved party has been unfair. So it's not just about that one specific decision. You can look at all the decisions that were made. In this case, there were a multiplicity of case management decisions in which the father felt that he had been unfairly treated. And when considering a submission that the judge has been unfair in his case management decisions over the course of proceedings, the fact that one party has been more successful than the other isn't by itself plainly of no relevance. So you really need to look at the case in whole. Actually, in this case, the court found that the reasons given by the judge for not recusing himself were inadequate, because he'd failed to engage with quite a lot of the points that had been raised by the father in his application for the judge to recuse himself. But ultimately, the Court of Appeal concluded that when each of his arguments was carefully examined, really there was nothing to the father's case. His case was unmeritorious, and consequently, the High Court was wrong to find that the judge was wrong and should have recused himself. So it's a handy one to have in the bag, also to explain to clients, as I explained earlier, why it is that even though they might feel the judge is really against them, they're not in fact biased.
That must be right.
And yet, we have all had those discussions with clients in the past.
Oh, also right, yes.
Yeah.
I, at the end, just wanted to touch upon a case from a few months ago, at the beginning of the year, first quarter, case of A and B and C before the Court of Appeal. Now that case is important for two reasons. It reflects on previous judgment of Mrs. Justice Knowles and confirms she was right in relation to her approach on the question of should we have in family proceedings actual definitions of rape, sexual assault, and it flows actual definitions of other offences being the wrong word, but other actions of abuse that a party might or might not have engaged in. And it's interesting for a few other reasons as well. It's worth reflecting upon. One of the point, and that question of definitions is why this case and the previous case for Mrs. Justice Knowles, and there's two linked cases and two appeals, are often referred to, and certainly why they made a bit of press at the beginning of the year. One of the points that is sometimes missed is a really good practice point, because what happened in this case at first instance before the Corder is the party produced an agreed summary of the relevant law. Without going into too much detail, it was identified by the Court of Appeal that this summary of the relevant law was wholly deficient. Actually, it was hard to get hold of a copy, but the court did get hold of it before giving this judgment and was able to see what the advocates had provided to the judge. And effectively, it was the wrong cases, the wrong law, and wasn't very helpful. And seems, this is me reading between the lines, to potentially have contributed towards the judge alighting on some legal points that maybe shouldn't have been alighted upon, that raised further questions about the soundness of that original judgment. Didn't go anywhere, but were unfortunate. It was so concerning that actually, if you turn to the end of this judgment, again, we'll provide it via a link, Lord Justice Peter Jackson, Lord Justice Jackson, felt the need to emphasise the point in the last paragraph of the judgment, noting that the case summary and the legal summary was insufficient, but equally, what we also see, so I think actually agreed legal summaries that are wholly deficient or unusual. I don't see many of those. Certainly, not many people send over wholly deficient legal summaries to me and go, how are we going to fix this? The other thing, though, Lord Justice Jackson identified, is that in the reverse, sometimes these lengthy boilerplate summaries of the law are produced and sent in, which canvass every single legal point that might possibly be taken at any time. And those certainly I've encountered quite a bit. And what Lord Justice Jackson says is the deficient summaries are clearly deficient and unhelpful, but also the very lengthy boilerplate, every tool and toolbox, any point that might possibly be taken or applicable in any case imaginable, equally as unhelpful. The actual provision of an agreed legal summary or an agreed summary of the law is an incredibly useful exercise to engage in, but it must be case focused and only setting out law that's actually likely to be helpful to the judge, or I would say referred to by the parties. Now, if the production of that focused case, and this is departing for judgment, is something that you don't have time for with your solicitor, or is something that's proving difficult to agree with the other parties, my opinion, this is now firmly away from the guidance of this judgment, my opinion is just leave it to counsel's position statement / skeleton argument. If you can't do, there's no obligation to an agreed legal summary, and if there's any problem with this at all, just make sure that you're setting out the law through your counsel's skeleton argument that you think the judge needs to be taken to accurately decide the case. And that's the best way forwards on that, I would say. Just my opinion, though. Hal may disagree.
No, I don't. I mean, I'd say that summary of the law is probably something you find more often in fair cases than you would necessarily in a private law scenario. So you might have a multiplicity of parties all referring to the same law. But yeah, I think that the indication is pretty clear. Please only give us stuff which is actually relevant. Don't just cut and paste from Hersham and Farthen and hope for the best, because they don't find that very helpful. Well, in the case of some of these judges, because they probably wrote those bits of the textbook themselves.
Exactly.
So yeah, fair enough.
No, perfect. And then on the question of rate definitions, section 3 definitions, the relevant bits, and they'll be flagged in the note we circulate, really the conclusions get tied together in paragraph 16 onwards of this judgment. And it's just reiterating what, as I said, had previously approved. But there is no need for a set legal definition of rape or sexual abuse, as we all know, I think, in family cases. And what's cited, RIAR, and as I've glanced at a few cases, what's cited from RIAR is worth repeating. In family proceedings, the outcome of a fact-finding hearing will normally be a narrative account of what the court has determined on the balance of probabilities has happened in the lives of a number of people, and often over a significant period of time. The primary purpose of the family process is to determine, as best that may be done, what has gone on in the past, so that knowledge may inform the ultimate welfare valuation, where the court will choose which option is best for a child, with the court's eyes open to such risks as the factual determination may have established. Then worth flagging the VHN citation, which is also further approved here. The family court should be concerned to determine, again, emphasis here on how the parties behaved and what they did with respect to each other and their children, rather than whether that behaviour does or does not come within the strict definition of rape, murder, manslaughter, or other serious crimes. Behaviour which falls short, this is the powerful bit, behaviour which falls short of establishing rape, for example, may nevertheless be profoundly abusive and should certainly not be ignored or met with a finding akin to not guilty in the family context. And that was just as powerful now as it was when VHN was originally published, I would say. And so for those reasons, a few other ones set out, the court is firmly against the idea of thresholded definitions. Have you met the criteria for this defined issue, whether it is rape, sexual assault, or any other quasi-criminal or other sort of defined offence? What we're looking at is the narrative behaviour within the case. And that, I think, is worth underlining and re-emphasising, is exactly what the court did at the beginning of this year.
Yeah. No, I think it's about so many of those actions which amount to crimes that's not really susceptible of family law process, where we're obsessed with nuance because the decisions of the family court is to do with what's the best decision for children, not whether or not somebody should be punished and deprived of their liberty. So,
Exactly.
but we've all come across judges who take a different view to that, and Reece is where you go to remind them that that isn't the case.
Yes, right.
So the last case in our pick and mix, well done, those of you who are still with us, is a case to do with a child's ability to instruct a solicitor. So the full citation, which will be in the handout which we circulate after this, is C Child Ability to Instruct Solicitor 2023 EWCA Civ 889. And it is an appeal from the decision of Foreign Judge McKinnell, who decided in a case where parental alienation was a factor, that a 14-year-old should be separately represented from the guardian. Many of you will have come across cases like this, often where one parent is absolutely adamant that children should be separately represented because they believe that the force of that child's feeling will be a compelling factor. And of course, we know so often that that isn't the case. The judgment addresses two issues. So the ability of children to instruct a solicitor directly and also meetings between children and judges. It's fairly lengthy, but it is worth having a look at. But in essence, there had been care proceedings which arose from a private law scenario, so parents who couldn't agree on what arrangements should be with their for their children, which was so acrimonious that they turned into care proceedings where there was a strong concern that one of the children was being alienated, actually both the children were being alienated by the father against their mother. Alienation in this case actually having been described as behaviour which turned the children away from their mother. So the court in the care proceedings decided the children need to be placed in foster care. And subsequent to that, the parents in separate proceedings applied for the discharge of the care orders. The reason why I'm talking about this is because the points I'm about to raise are common as between public law proceedings and private law proceedings. So yes, I know what I'm talking about care case, but it is relevant to your practice. In the care proceedings, they had instructed a psychiatrist who reported on whether or not the elder child, A, who's 14, was able to instruct solicitors separately. And the psychiatrist actually concluded that he wasn't, that the degree of influence of the father over A was extreme and damaging. And the risk wasn't just of A parroting things said to him by his father. It was actually much more insidious because he had absorbed his father's belief system and it was incredibly damaging to him. And also that whilst he could understand the facts and the process of litigation, he had absolutely no appreciation of the difficulty or the emotional harm that would be caused to him by other family members, by the court environment, or just reading about them. And in the pro camp were his intelligence and the strength of his feelings, although the psychiatrist remarked that that was based on a number of false premises. And the judge at the final hearing in the care proceedings made a number of findings about the damaging nature of the parents' relationship, and also that the father had alienated the children from their mother by referring to in derogatory terms, by accusing them of lying to them and abusing them, encouraging them to act in a secretive manner and exerting influence over them in a really, really damaging way. Bizarrely, in the subsequent discharge proceedings, the court formed a different view, even though the same psychiatrist was instructed to provide a report and provided a comprehensive report, which again was full of nuance and explained the reasons why they're able to understand the facts and the process of litigation, including the functioning of the different parties, what lawyer is, what the court is, etc., saw absolutely no risk or difficulty in continuing to be involved in those proceedings. But the judge decided to take the opposite view to the expert and decided that A was actually able to instruct somebody separately to this, and that decision was subsequently appealed. Now, a few points. The first is that, as I'm sure you all know, the judge is the final arbiter of whether a child has sufficient understanding to act without a guardian. And as we all know, of course, these days, it's commonplace for children to meet judges. The difficulty with this judge, if you read the full judgment of the Court of Appeal, is that she relied too much on her own assessment of A's understanding, because she had a meeting with A prior to making a decision that lasted 1 hour and 25 minutes, which is long by any standards. And in her decision, she decided that he was sufficiently intelligent and that he had sufficient understanding. And she cited, from my assessment of him, I do think that he is emotionally mature enough to be able to instruct solicitors. He has a strong and clear wish and has had for some time to have his voice heard. Of course, in that sense, that's no different from the conclusions that she could have reached in the initial care proceedings, where she didn't think he should be separately represented. So her decision was appealed, and the Court of Appeal, whilst being sympathetic to the difficulty of a judge making a decision at the end of a very long day, found that she had fallen into error in substituting her assessment for that of the expert without giving any sufficient explanation. The judgment also goes into some detail about the right approach to meeting with children. So the judge needs to give close consideration to the 2010 guidance and the numbered guidelines therein. I'm sure you're all familiar. It's a 2-page document. It's very straightforward because that will increase the likelihood that the meeting is actually going to be valuable to the child. It's not supposed to be, it's explicitly not supposed to be for the child to substitute their assessment of that child's competence for that of an expert. And it avoids the risk, therefore, of the meeting turning into an evidence gathering exercise. And that risk will increase if it's a very lengthy meeting. So that's another observation that was made. And where the judge does consider that something of evidential significance arises in the meeting, then the party should be made aware. And that was another problem in this case. The first that the parties realised the extent to which the judge was going to rely on her own assessment of this child was when they read the judgment, because it hadn't been sufficiently canvassed when they made their submissions before the judge. So in summary, she fell into error by making her own assessment in circumstances where there was an expert assessment which very clearly said the opposite. She didn't set out any of the reasons why she departed from that expert view. And she also failed to appreciate that actually A's responses indicated that he rejected her assessment of what had happened in his family and was under the delusion about the cause of the problems. And actually, by allowing A to instruct his own solicitor, it would only perpetuate that really damaging narrative. So even though this judge described A as very mature and insightful, there was the fact, the insuperable fact that was insufficiently addressed in the judgment, that a psychiatrist and actually also a psychologist who was instructed in the proceedings had both given evidence of emotional maturity and the fact that this child was lacking in insight. So there's a general observation that I would make about this, which is that there is such a temptation in cases of this type that because you have a child who's articulate and apparently intelligent, you should just go with what they're saying if they're of sufficient age. But of course, we all know that children who have been exposed to very grown-up conversations often do come across as more mature than in fact they are, and more intelligent than they actually are. Interestingly enough, A's younger sister, by about a year, was in the earlier proceedings found not to have the capacity to give instructions, partly because although she was very cogent about certain things, i.e. the matters in hand within the proceedings, when she discussed other things, it was very clear that she didn't have sufficient maturity. So she was only mature in one very specific aspect of the matters that were being discussed with her. So there we are. That is in fact the end of our pick and mix
Yes, no, I was about to say.
I hope that was readily absorbable.
And I hope you can come and see our new chambers if you haven't already been here.
Yes.
Brilliant. Thank you so much for attending.
Thanks so much for attending. And we'll see you again, hopefully, at the next seminar, which is on the 23rd of November.
Brilliant. Thank you so much.
Thank you very much.